Was the verdict in the Johnny Depp case the truth? No. The answer is no. I'm going to explain that because I know a lot of people who watch the trial agree with the verdict, and they think that this verdict spoke the truth. The truth was finally revealed. The truth will set you free.
And the truth shall set you free!
And that's what the jury did. It looked at all the evidence and it came to the conclusion, this is what happened. Here is the truth. And Amber's a liar and she has to pay him money, and that's the verdict. One thing you see online is there is a lot of people live in a world of a great deal of certainty. He's guilty. He's innocent. He absolutely did it. He absolutely didn't do it. She's a liar. He's a liar. Like they know these things. And when you watch a trial and you see all of it, part of it or whatever, in the evidence that's presented, and the jury gets to a conclusion that agrees with you, it's nice to think, well, there it is. The whole legal process came to bear and supported my already wise conclusion that this was the truth. If you don't get the verdict you like, then the jury's stupid, runaway verdict, idiot. They watched social media. They were on the take. The judge was biased. The judge made mistakes.
I object, Your Honor. This trial is a travesty. It's a travesty of a mockery, of a sham, of a mockery, of a travesty, of two mockeries, of a sham.
But both sides in that case are putting too much weight on what the jury did, what it came back with as a verdict, and the process itself, what the court even asked the jury to do. Because the jury in the Depp case was not asked to determine, quote unquote, the truth. They were asked something far less. For most of us, I think, from a conceptual standpoint, we view the truth as something essentially real. It exists. If you can bring enough resources to bear, enough information to bear, enough focus to bear, you can find it like a gold nugget in the ground. If you can work hard enough and do the right things, you'll discover it. It's there. You may not see it right away, but you can get to it. If someone is murdered, there's a truth out there. Someone murdered that person. Now, can we find the evidence to prove it? Can we get there? Can we get the facts to uncover this hidden truth? That's a separate question. We all realize that. But I think we all agree there is a truth there. That happened. Someone did it. The question is, can we, limited as we are as humans, find out the facts, the real truth that can show that can expose that, what the truth is. But let's take a different example. Let's say you work in an office building and a bomb threat is called, an incredible bomb threat. You evacuate. Bomb squad comes through, they come back out, and they're about to leave, and you say, well, is it safe to go back in the building? And the head bomb guy says, yeah, probably. I mean, I'm not sure, but probably. Do you feel like you got enough information to walk right back in that building, get back on the internet and start surfing again when you're supposed to be working? Maybe not. Maybe you're still nervous. Like, that answer is not comforting. Like, you didn't say, oh, yes, it's all clear. You said, probably. Not very reassuring. You're not, at that moment, confident that you know the truth. There's a bomb in there. There's not a bomb in there. Was the effort expended to get you and everyone else to the conclusion that you know the answer to that question? So he leaves, and bomb guy number 2 comes by, and you ask him, you're trying to get a better data on this. Hey, is it safe to go back in the building? And this person says, I'd give it better than a 50% chance. Definitely at least slightly over 50% that there's no bomb in there. I can't tell you more than that, but I can at least get you more than halfway. You going back in the building and log back in? Maybe not, because again, you're sitting there thinking, I don't know if there's a bomb in there or not. And the next guy comes along and you ask him, and he goes, now, I personally cleared this building, and I will tell you beyond a shadow of a doubt, beyond any doubt that I can see, that I've cleared many buildings, and in my opinion, that building is clear. I would certainly go in there myself. I'd recommend my family to go in there. I'm telling you without a doubt that building's clear. Now, absent verifying it yourself, you're feeling good about this. This is the bomb guy, the head guy, whatever. He's telling you, yeah, this is clear. Now you'll go in there. But those probablys and those 50%, you don't know that that's the truth. You're not comfortable with that where the stakes matter. Well, in a civil case, that's often what the standard is for the jury to come back with a verdict, just probably or slightly more than 50%. When a case goes to court, there's a lot of talk about evidence. People are going to be sworn in. They have to testify under oath.
You swear to tell the truth, the whole truth, nothing but the truth.
I do.
I swear to tell the truth, the whole truth, and nothing but the truth. So anyway.
They can be imprisoned for perjury if they lie. Documents are authenticated. Evidence is tested, validated. experts are produced with background to show that they know what they're talking about. All these things are designed to elicit the truth and make sure that the things that come before the jury have an aura of truth, and they can be challenged by the other side. So that gives further credibility that what you're hearing is the truth, or else the other side would shoot holes in it. If they do shoot holes in it, then you will know to disregard it, and you'll make your judgments accordingly. And so people, I think, gain the opinion that when a case goes to court, the primary or main situation at stake is the truth. But the truth is not the overriding supreme goal of the justice system. It's an important part of it because we want trials to be fair, we want the justice system to be fair, a system of morality, etc., how the laws are enforced. It's important, but it's not the overriding goal. Really, in a criminal case, the court is there to decide whether the state can exercise its authority over a person or not. And in a civil case, it's there to decide a contest, a controversy between people. Does somebody owe money or not? And get that case over with and finish that controversy. And getting to the truth is an important aspect of that, but it's not the only one. And cases will be decided whether the jury ends up knowing the truth or doesn't know the truth. In some cases, if they don't have confidence, they'll find for the other side. But this case is ending without getting to the quote-unquote truth, in many cases, criminal and civil. But before that case ever gets to the jury, oftentimes before it ever shows up on TV or whatever, the system is already doing things that shows that truth is not the supreme overriding factor in what it does. Truth is just an element. For example, I've done other videos about statute of limitations cases, which incidentally relate to the truth in terms of the age of evidence, but they will bar a case even if the case is completely truthful, completely has merit, just a decision society makes. The truth is not as important here as that the case is brought in a rapid manner that we say it has to be within this time frame. Truth, second place. In a criminal trial, a defendant cannot be compelled to testify against himself. That's in the Constitution. And you can't draw a negative inference from that in a criminal case. The judge won't let the prosecution do that. But if that defendant were the witness to the crime, maybe because he did it, why shouldn't he have to testify? Get up there and testify. Everybody else has to testify. If the truth matters, the person should have to testify. And if the testimony hurts the person because he committed the crime, shouldn't have committed the crime. But if the truth were important, you would have that person testifying or have a penalty for not doing so. But we make the decision that we want to limit the power of the state and set some parameters for individual freedom and autonomy and respect for the individual. And one way we do that is saying that the state cannot compel somebody to testify against themselves. And that ripples throughout the criminal justice system. Sometimes confessions that may be truthful are thrown out because the Miranda warnings weren't given the right way. Exclusionary rule: if the police find evidence in a way that is not lawful, that evidence may not be used, even if it's completely truthful evidence. Sometimes under Rule 403, if the evidence is really bad but only contributes a little bit to the issue of the case, the judge, even if it's true, the judge will say you cannot put that evidence in. It's just too prejudicial. But it's still true, potentially, so why shouldn't the jury hear it? Hearsay evidence is a bizarre one. It's basically a declaration made outside of the trial by someone that gets offered for the truth of the matter asserted. What's bizarre about that is you can offer this statement of the person into the court as long as you're not offering it for the truth of the matter asserted, so something incidental to it. So say I ask the witness, did you ask this person what time it was? And then the other attorney objects, says he's calling for hearsay. That's what his answer to that was: a statement made out of court. He wants to get in what time this happened, that you can't do that. And then I will say, Your Honor, I'm not offering it for the truth of what time it was. I'm offering it to show that this person was wearing a watch. And so when he answered the question, he looked at his watch to answer it. So did he tell you what time it was? Yes, he said it was 2 o'clock, and he looked at his watch. Now I want the jury to hear the 2 o'clock, but I'm telling the court that I want it in there to show that this person was wearing a watch, not what time it was. So there are bizarre locutions on evidence often, obviously, in cases. Courts can have limits on jurisdiction. They can't get everybody to testify that needs to testify. A lot of things happen before and during a trial that truth is not the central angle that is being protected. It can be limits on the state's authority. It can be expediency of the court. other judgments and things like that. Lots of things come into play. Truth is not the supreme overrider. And that gets us to the jury. So does that change when it gets to the jury? Does suddenly the truth become the only thing that matters? And they got to know it in order to get to a verdict. A verdict is kind of an ancient word anyway that has to do with speaking the truth. And the answer is generally no. There are generally more or less 3 burdens of proof that a jury is given instructions on. In other words, after you hear all the evidence, to what degree do you have to believe something happened or not happened, the truth, before you decide a verdict for or against any of the parties in the case? The first one that people hear the most about is beyond a reasonable doubt, and that's generally in a criminal case. And that's the closest we get to telling the jury, you need to know what the truth is when you do this. If you're going to put this person to a criminal penalty under the authority and resources of the state, you need to believe beyond a reasonable doubt that all the elements of the state's case are true, that they happened. So that's pretty strict. That's saying you got to find that gold nugget for all these elements. That's as close to declaring the truth as we're going to get. Now, along the way, they made it sometimes hard for the state to do that. The defendant doesn't have to testify. In a criminal case, you can't make a negative inference from that. In a civil case, you can. The person is presumed innocent in a criminal case. That's not really a factor in the civil cases. And then the state has to prove every element beyond a reasonable doubt. The defendant, hypothetically, doesn't ever have to say anything. He can just attack what the prosecution's doing. So on one side of this case, we are asking the jury, if you want to find guilty, you've got to find the truth here. And if you have doubt about the truth, then you find not guilty, not innocent. Okay, that's not what they're tasked to do. The defendant is not there to prove they didn't do something, so they don't get a declaration that, you didn't do it, you're innocent. Just simply that the jury did not find the prosecution's case compelling. So you get the truth that it is compelling, or they didn't make it. In a civil case, you have either generally clear and convincing, which is a fairly high standard. Yeah, firm belief. Yeah, that happened. That happened. Or probably, which is most civil cases, and was the predominant instruction in the Depp case. Not, we know this happened, or we really have to firmly believe it, but just that probably happened. More likely than not, 50.1%. Now, they may firmly believe it. They may just slightly think, well, this person's a little bit more credible than the other one. I think that's probably the way this went down. I'm going with this one. Because in civil cases, we just got to adjudicate disputes. We're not putting somebody in prison. That kind of instruction is what we give due to the limits of the evidence. But it's not really the truth, per se, is it? So in the Depp case, the jury was tasked on all the elements of defamation except for malice. We'll cover that in a moment. To decide whether the elements were met or not based on preponderance of the evidence, greater weight of the evidence. This is the more likely than not, probably kind of standard. Who was more persuasive? That's all you got to find. You don't have to say, well, I kind of believe him, but I don't know, so I'm not going to. This is not a criminal case. It's just who was slightly more persuasive than the other one, the preponderance. And then the jury comes back yes or no on either side of that. It's a civil case. From the malice aspect of the defamation in this case, because he was a public figure, then the clear and convincing standard was applied just to that element. And that says you have to have a firm belief that this is correct. Now, of course, the jury in this case returned liability on all of these things. And the jury certainly could have had the opinion in their own minds that this is beyond a reasonable doubt. I have a firm belief about all of it. Or they may have actually followed the judge's instructions, which are extremely academic and very lawyer-like, in that for these things, it just has to be a preponderance of the evidence. And for this thing, it has to be a greater weight of the evidence, and it has to be clear and convincing, etc. And I don't think people in real life think that way. They're going to listen to both sides of it, and they're going to believe one or the other. And the best you can hope for in a criminal case is they will also take into mind that, but I got to be really, really sure before I return this guilty verdict. I think that's how most people look at these things, rather than torturing themselves with lots of words that are in the jury instructions about how each element gets looked at. You're looking more at whose story do you believe. And when you look at it in that light, I think two things, in my opinion, are true. And one is, if you take the jury verdict in the Depp case as complete vindication that you know what happened, you're asking more out of it than it was designed to give. Not that you're wrong. On the flip side of that, when Amber Heard's team takes this verdict and says, well, this is the jury was corrupt, the wrong juror was there, the evidence was wrong with the judge, they were searching social media, all these things they say about the jury, it's unfair to the jury. The jury didn't have to go back into the room and conclude that this was beyond a reasonable doubt. The sad fact for her side is all the jury had to do was listen to the evidence and decide, I think probably he's telling the truth on these elements more than she is. His side of the case is at least slightly stronger than hers. So for that to be that narrow of a decision point for them, how can Amber Heard's team sit there and say this is all wrong? There was evidence presented on both sides. The jury could have gone either way in this case, and it wouldn't have meant the truth was necessarily found in either direction. I happen to think they were largely correct in this case from watching it on my standpoint, but that's just listening to the story, buying into the evidence and my own biases and things like that. That's why you have several jurors. That's why you leave it to the people and not just a judge. This is the people's system. Certainly, lawyers have no right to claim any special control over anyone's perception of what the truth is. Everybody has a right to that. I think in fact, for lawyers, if you're a litigator, often your job is to win. And so a lot of the time, your job may be to get the truth out, but it may be to take every single effort you can to obscure the truth and create a narrative favorable to your client that may not be that nugget of gold underground. It might be something else. So the way I see it is this, that you as a person, when you evaluate something, whether you're sitting on a jury or whether you're just watching something or you hear about it or whatever, you got to know you're bringing your own biases to it. You got to know you're dealing with limited information. You got to know that once you start to decide on a narrative, there's a good chance that you're going to pay attention to things that reinforce your pre-existing belief and begin to disregard those things that don't. And that's okay. You got to form a narrative. You got to move on with life. The decisions get made every single day without having exhaustive investigations into what the truth is. It's a very natural mechanism and a way to think. But on the other hand, I think it's good to constantly challenge yourself and try to recognize your own biases. Look at the other side of the equation of whatever it is you're deciding about. Challenge those things, and it'll help you make a more informed decision. It does lead to more uncertainty on things, and that's not as fun as just declaring that you know everything. But on the other hand, it's a challenging way to think. It exercises your mind, and I think it'll give you a more quality insight into what it is you're actually trying to look at. And I'll give it the final example here in the Manson case is just as one example. Obviously, we know that he's had several accusers come forward in a short period of time, that they all came forward and said, hey, he abused me, and similar allegations of the conduct that he did. And the people who believe Marilyn Manson can say, there it is, that's evidence of a conspiracy there. These people met together, came out with the allegations almost simultaneously. They're very similar in scope. And so that's further evidence that this is all a fraud. But people on the abused side, the ones who believe these women, know that it is true that sometimes that first logjam has to break. That's just true. I'm sorry, that's true. Sometimes the first victim to come forward is the one that will break the logjam for people who were actually victims to come forward after that. Now, that doesn't mean it's true, but that does happen. So if you take that piece of information, that there's people out there making similar allegations, and decide that concludes that that helps you conclude that you are correct, you're asking too much of it. It's just another factor that has to be examined, like the motivation. What do they have to gain by lying about him? Well, in this case, people make the claim that they do have something to gain, that they get themselves publicity, which is what you need if you're in Hollywood. Yeah, I got it. That's pretty persuasive. On the other hand, the other side will say, well, there's still a stigma attached to it. This is a hard thing for anyone to go through. People don't just do it for the hell of it. But there have been false abuse allegations made in the past in this state. There was the Duke Lacrosse case. There was the child satanic cult cases. So it does happen. On the other hand, real abuse is underreported, under-prosecuted. So there's that side of the equation. So my suggestion would be to have some humility in yourself about your ability to know everything. And so even if you're confident in your opinion, try to keep an open mind, and you will examine factors as they come to light. I think that's going to make it more interesting for you to look at these cases, and it may help you make better quality decisions and other things you do in life too. So that's the end of this. That's a look at the legal system, which is not there just to tell you what the truth is, but to get these cases resolved and move forward. I'll talk to you later.